स्टार्ट कर दें?
बिल्कुल।
मैम थोड़ा सा ये कैमरा को प्लेसमेंट ठीक कर लें एक बार। हाँ ठीक है। Good evening friends, and amongst us we have senior advocate Susheela and those who have been connected with Beyond Law series and even otherwise know Susheela ma'am is a senior advocate, a columnist, an author, mediator, trained mediator, coupled with the fact that she herself trains the mediators. And once you start introducing her in the fullest, you can even give that 1 hour slot we have for introducing the speaker, who is not only having immense knowledge, but also her passion to immensely share it with the people in the public at large is what makes her separate from the common man. And we can say that when we talk about the topic of substantial law and how the journey of law, substantial law under the section 100 of CPC has traversed, I can say that substantially we will be having that knowledge after learning her from within a period of 1 hour. A previous session with the Beyond Law CLC is already exceedingly doing well. And since it's a weekend, we will not make much time in this regard and we'll ask ma'am to share her knowledge. And on the request of Susheela ma'am, we can only say that just take out your pen and pencil so that you can jot down some of the judgments which she said that off the cuff also she would be sharing, besides what she will be sharing on the screen sharing. And screen sharing part can always be noticed, but what she will be speaking off the cuff, you may have to jot down. Be that as it may, this session is already live on the YouTube and Facebook. You can download that video or watch it again and note it again. But to facilitate once you're watching it live, it's in the fitness of things that you jot it right now. Over to you, ma'am. And thank you for sharing your knowledge. And before we proceed with the session for today, I'll request that kindly share the book which revolves around on the facet what we are going to talk about. And those, I can say that that book has been very written in a simpliciter manner, which everyone will enjoy. And it will also be palatable to the mind to understand how you have to build a substantial question of law, how the legal journey of substantial question of law, and what is the relevance under the section 100 of Code of Civil Procedure. I'm just share the cover page of the book. So it's a book, as we see, substantial question of law, law relating to regular second appeal. And those who will read this book will keep on regularly reading this book because it will always enrich them. Over to you, ma'am.
Thank you, Mr. Vikas. It has always been an immense pleasure to be part of Beyond Law CLC. And I'm really happy that youngsters like Mr. Vikas and Trivikram Associates also have joined hands together and they are taking this journey forward. You are doing yeoman service to the fraternity, and I would like to say that I'm one of the beneficiaries. Many a times I sit, take notes, read, listen to whatever has been said, and amazing sharing of knowledge by several stalwarts in the field. I'm here only to learn from the other side. The question here is, today we are dealing with a subject which is substantial question of law. I'm confining this session only to second appeals, regular second appeals under section 100 CPC related to civil suits only. That clarification I would like to give and then proceed. I would like to share the screen. One second, please. Yes. Something went wrong, Mr. Vikas. Yes. This is the book I was referring to. Yes. Am I seen here? Can you see me? Can you see me?
The screen sharing hasn't started.
Oh, there's something wrong then. Wait, please.
Afzal, probably you're not logged in through the, you're not connected on the audio. Ma'am, you can do your screen share.
One second, I'll just reconnect myself. There is something wrong here.
So those who have missed the previous webinars of Beyond Law CLC, they can like, share, and subscribe to that channel for previous insights, including by Susheela ma'am. Yeah, Afzal, everybody is hearing it. We're about to start the screen sharing, and
One second, please. 1 second. There is something wrong here. 1 second. Is it there? Has it come there?
no, ma'am.
No. There is something wrong here. Why?
Ma'am, we can do without that. We will share the this thing on the links of the WhatsApp group.
1 second, please.
Yeah, it has started.
Screen sharing has started.
Yes, it has started.
Can you all listen to me, please? Am I audible? Am I audible?
Yes, ma'am.
Sorry. Sorry for the inconvenience caused. Now you see, when we see this substantial question of law, I would like to confine myself only to civil suits. What we have today as Section 100 CPC in our statute is a result of 54th report of Law Commission of India, which was submitted in 1973. Because of this, we had an amendment, and now what we have is subsequent to that 1976 amendment. Two decisions. I request the young members of the bar to note down. These two decisions change the scenario of substantial question of law itself. I can go to that extent and say, Santosh Hazare versus Purushottam Tiwari, 2001 3 SCC 179, And another one is Hero Vinod's case, AR 2006 SC 2234. If anybody wants to argue or make his submission or her submission before the High Court regarding admission, at least with regard to admission, if you are thorough with these two judgments, probably you will get through that stage. These two decisions must be in the court file of every advocate who is going for admission as far as this, admission of regular second appeals are concerned. I'll get back to these decisions little later. Now you see, what we have here is section 100. Let us see the components or elements that are there in section 100. An appeal shall lie to the High Court from the judgment and decree passed by the first appellate court. First we go to the trial court. After trial court, we go to the second court, that is regular appellate court or first appellate court we say. Then we come before the High Court under section 100. Section 101 says an appeal lies to the High Court only if the case involves a substantial question of law. What does it mean by involving? And then what is the meaning of substantial question of law? Let us come to it later. But the fundamental factor that we need to consider here is, if a case does not involve a substantial question of law, the appeal shall not lie to the High Court. That means the judgment of the first appellate court becomes final. That's where we have to be very careful to see to it that we have to bring it and weave it in such a way and present it in such a way that the case involves a substantial question of law and show to the High Court, look, there's a substantial question of law involved here and the case needs admission and hearing, and then we may get through that hurdle also at a later stage. Now you see, another important aspect here is 100, subsection 2 of 100 also says, appeal lies from an appellate decree passed ex parte. Notwithstanding the judgment being passed ex parte, you still have a right to come under section 100, provided 101 is taken care of. That is, if the case involves a substantial question of law. This is an important aspect we generally ignore. The third is subsection 3 of 100 clearly says, the memorandum of appeal shall precisely state the SQL. So that means you cannot file a regular second appeal without the substantial question of law, which according to you are the substantial question of law. Those substantial questions of law have to be made part of the memorandum of appeal. This is the next requisite. Fourth one says, that is 100 section 100 subsection 4 says, the appeal shall lie to the High Court if it involves substantial question of law. If the memorandum of appeal specifically states the substantial questions of law. And then the fourth one, it says that the High Court should be satisfied that there exists substantial question of law and it shall formulate the same. That means, notwithstanding I as an advocate, I might have framed several substantial questions of law, 4 or 5. The court should come to a conclusion and it should feel satisfied that there exists substantial question of law. Many a times the courts may repeat or reiterate whatever the substantial question of law that is framed by advocates and given in the regular second appeal, memorandum of regular second appeal. But it is not mandatory always. Court may just go through these substantial questions of law that are framed by the advocate, but or the party appellant. Nevertheless, court can, if the court comes to a conclusion and it feels satisfied that there exists substantial question of law, that substantial question of law alone will be formulated. So it is the court that formulates the substantial question of law, though we may give, it is what we present to the court in the memorandum of regular second appeal is nothing but draft issues, something like draft issues, that's all. Court is not bound by it. Many a times the substantial question of law we raise may not be appealable to the court. Court may find there is yet another substantial question of law and it can formulate on its own also. 105 says Appeal shall be heard on questions so formulated. This is an important aspect. We have several times come across, of course, we have also argued many a times on so many things when we are arguing regular second appeal. No, it's not permissible. An advocate who is submitting before the court has to confine his submissions with regard to the questions so formulated by the High Court. We have to note down the questions of law formulated by the High Court and then take the court through that. So another important aspect is we should not ignore to take down what is the question of law formulated by the court, and by the time we move from admission to final hearing stage, we should know exactly be prepared to address our submissions only on the questions so formulated. If the questions are not formulated by the court, we need not address those aspects at all. But there is yet another thing. Please see here. There is a proviso. Section 105 also says, supposing the court at the first instance, while listening to an advocate for the appellant or the appellant himself, will come to a conclusion there is some substantial question of law and formulate it. But nevertheless, even though it is formulated by the court itself, the respondent has got every right to argue that the case does not involve substantial question of law. Maybe the High Court has formulated it. Still, you can say, look, at the time of admission, this court has formulated this substantial question of law, but I am here to convince the court that this substantial question of law does not exist at all, and this case does not involve this substantial question of law. Look at the wonderful arrangement that's made here in this provision. Really, it's very laudable effort of the legislators. So High Court formulates the substantial question of law. Still, I can say, look, this is not the substantial question of law involved in this case. Let me argue. So on the respondent side, we can always make this effort. Now you see, then whether the court should dismiss the case need not be, because there is proviso to section 105. You please see this proviso to subsection 105. It says, court can hear the appeal on any other question not formulated by it if it is satisfied that the case involves such substantial question of law, but after recording reasons. Court formulates substantial question of law. I, as an advocate for the respondent, come forward and say, look, this substantial question of law do not arise at all. Then the appellant counsel can still persuade the court to say, maybe respondent is right, these substantial questions of law do not arise, but look, this substantial question of law arises, or these substantial questions of law arise. Can you please consider this? Or the court on its own may say, look, maybe the substantial question of law framed at the time of admission do not arise, as you say, but these questions of law arise. So I will record reasons that I am satisfied that the case involves such other substantial question of law. So it can modify or it can add additional substantial questions of law also. This is one area where we have to be very careful, and we can be persuasive and we can try to convince the court. Because many a times what happens is we just ignore section 100 subclass 5, and also we ignore proviso to section 105. This is one aspect I would like to request. So now, if we have to remember, 5 steps may have to be remembered. Number 1, regular second appeal lies only when there is substantial question of law. Otherwise, the answer is strict no. RSA can also be filed against an ex parte decree. Third, the memorandum of appeal should contain the substantial question of law that according to you, which is involved in the case. Fourth, the High Court should be satisfied that there exists substantial question of law which is involved in the case, and High Court should formulate the substantial question of law. And respondent has got a right to argue that the case does not involve such substantial question of law at all. Now, what was this section 100 before amendment we should see? Before amendment, the section 100 CPC permitted us to go on second appeal if the decision given by the courts below is contrary to law, or the decision had failed to determine some material issue of law or usage having the force of law, and there was substantial error or defect in the procedure. Please see, these were the aspects that were there in section 100 before amendment. Why I am stressing on this aspect is many a times we argue about procedural irregularities committed by the courts below. Now post amendment, this is not permissible at all. Any procedural irregularity, look, this document is not marked, that is not done, this is not done, everything, all that procedural irregularities or procedural error or defect in the procedure cannot be considered as a point to consider your regular second appeal. These were available before amendment. Post amendment, these provisions are not available. This is not available. Now you see, I refer to two judgments, Santosh Hazari's judgment and Hero Vinod's judgment. They brought in a veil of change in the understanding of substantial question of law. Before that, I would like to request you to consider, those of you who are interested in general reading, please read 54th report of Law Commission of India. There are several suggestions given in respect of various other provisions of law. But about section 100, there is a specific reasoning given. You have to go through that. See, search for absolute truth is something. I, as a plaintiff, will be satisfied only when from first court to last court, if the court says plaintiff suit has to be decreed. The defendant would always be, according to the defendant would always be satisfied only if the plaintiff suit is dismissed from the first court to the last court. Wherever there is a change, the other person will take it to the next step. How long can we go? How far should we go? The search for the absolute truth in the administration of justice, it may be laudable, but nevertheless, one point has to be considered by everyone. There has to be a reasonable restraint. In other words, this search for absolute truth, I am right, I am convinced so much as a plaintiff. I want everyone also to be convinced, but we have to reconcile with doctrine of finality. If we do not reconcile with doctrine of finality, what happens is there can never be certainty to law. Why people come to law? I and my opponent fight with each other. We don't agree on something, or there is no consensus between us. We want somebody else to decide. Who has to decide? The first court decides. Not agreeable. Second court, not agreeable. Then third court. How long you want to take it? There has to be a full stop somewhere. That's where the court said that the larger interest of administration of justice must prevail over litigants' individual interest. That's where the section 100 was amended. And that amendment is, according to me, I'm speaking for myself, is wonderful. It is juristically sound, and it's also pragmatically completely wise. That's where we need to consider. See, first appeal may be an unqualified right. If you file civil suit, then regular appeal we file. It may be an unqualified right. But as far as it comes to second appeal, the answer is a strict no. It is not an unqualified right. It's more in the sort of, it's like a luxury. Only few can afford. Then in order to achieve it, you have to follow strictly what the law requires us to do. With this background, let us see. Now you see, can the court travel beyond the grounds specified in section 100? The answer is a clear no. If you read the judgment in the Kopisetti's case, 2009 4 SEC 244, the court said the legislative intention in bringing an amendment to section 100 was so clear that it never wanted the second appeal to be a third trial on facts. Please see how nicely they have used these expressions. It never wanted the second appeal to be third trial on facts or one more dice in the gamble. How beautifully they have used. Okay, I have lost there. Let me try High Court also. No. If you have no substantial question of law supporting you, which is involved in the case, you can't play here because it is not a dice in the gamble, one more dice in the gamble. No way. That's where they said you can't travel beyond the grounds specified under section 100. They also said in Manohar Lal's case, they said you cannot defeat the purpose of section 100. If you read the number of citations, of course, my book has got several citations, hundreds of citations I have referred to. So, several citations are there, which says that high courts are forgetting or ignoring the purpose or objective behind section 100, which should not be done, is what is the strict mandate given by the Supreme Court. Now you see, if you see Gurudev Kaur and others versus Kaki and others case, 2007, 1 SCC 546, the court in this case, Supreme Court, has referred to what is stated by the Judicial Committee of the Privy Council in 1890. Look at this. How nicely our courts are functioning. Only when we read several judgments, you feel proud about the journey we have gone through and how we are taking law, how the law is evolving from one stage to another. From 1890 to this 2007, how nicely the court has tracked the events. You please see. It has a reference to what is stated by the Judicial Committee of Privy Council in 1890 in this case. It's a wonderful judgment. I request the youngsters to read this. The Apex Court said, an RSA, regular second appeal, cannot lie on erroneous finding of fact. However gross or inexcusable the error may be. Please see here. There is a finding of fact which you feel that it is completely erroneous. This finding of fact given by the trial court is, or the lower appellate court, confirmed by the lower appellate court, is completely erroneous. It may be erroneous. It may be inexcusable. Both the judges have gone wrong. Nevertheless, it does not give you power to come in appeal in second appeal. The court ordered, the Supreme Court in this case warned that a high court cannot add or enlarge the scope of section 100 as stated in CPC. Whatever is there, you have to strictly go by it. You can't enlarge the scope. Look, there is an erroneous finding of fact. You can't. What section 100, what it says, I refer to 5 stages, how it has to be done. You go strictly by that. Only when it involves a substantial question of law and it formulates a substantial question of law, it can go ahead with the second appeal. Otherwise, on erroneous finding of facts, you cannot knock the door of the second appellate court. This is one thing that we have to be very careful. Now you see, this Viray Ammal's case is one case where the court said the objective intended by the legislature is frustrated. Look at this. We argue something and the courts pass some order, but ultimately when the matter goes to Supreme Court states something else. Supreme Court says the objective that is intended to be achieved by amendment is completely frustrated. Whatever was there before amendment is many a times taken care of and submitted by us before this second appellate court. And the second appellate court in many instances has considered them, and the Supreme Court has set aside those orders because court said liberal construction is not permitted. Liberal construction of what? Of section 100. That's where we should be very careful. Again, in Municipal Committee, Hoshiarpur, this is a wonderful judgment, 2010-13 SCC 216. There the court says that intent of legislature you cannot ignore and you cannot enlarge the scope of section 100. This is another aspect, and this case you have to be thorough with, because this judgment for the first time said formulating a substantial question of law is sine qua non for any regular second appeal. That means we are coming across several situations. Of course, I am also benefited. Many a times I was also benefited when I appear for the appellant. We say this is what it is, this is what it is. The court will say, let us issue notice. Then we'll say, Swami, my lord, an interim order may kindly be passed. The court may pass an interim order also. But are we right in doing so? No. Without formulating a substantial question of law, even notice cannot be issued and no stay order can be issued. That is the law. I will take you through that provision also. See, one is cannot enlarge the scope under section 100, and sine qua non, formulation of substantial question of law. With regard to that also, you have to go through this municipal committee Hoshiarpur's case. Now you see, forget about the precedents. Let us keep the precedents aside. Even section 101, it's a very simple section with 2 lines. It says second appeal does not, you cannot entertain a second appeal on any other grounds, no other grounds, any other grounds than the grounds mentioned in section 100. That means to say, whatever is mentioned in section 100, you have no right to travel beyond that. In fact, if you read section 100 very meticulously and section 101, wherever you are appearing for the respondent, you are empowered like anything. Wherever you are appearing for the appellant, your struggle is to be very hard. You have to make sincere efforts to make out a case and take it forward till the end. That's where section 100 and 101 arm section 100. That's also an important aspect which you need to see. Now you see, section 100 uses the word substantial question of law. We have to clearly have in our mind the distinction between question of fact, question of law, and substantial question of law. That's where when you are arguing for respondent, you can always point out, look, this can only be a question of fact, or this can only be a question of law, but not a substantial question of law. My opponent may raise these aspects. So, in order to ensure that I get my regular second appeal allowed, I should see to it that the substantial question of law, which I have stated in my memorandum of appeal, or the one formulated by the High Court, may not tomorrow be taken out as only a question of fact or only a question of law, but not a substantial question of law. It is here we need to have a clear, candid understanding of what's a question of fact, what's a question of law, and what is a substantial question of law. These 3 aspects are very important. Now you see, when we see question of fact, we all know that facts exist. They just exist. They will not have any meaning at all. Facts get meaning because of the surrounding circumstances and situations. So, what's a question of fact? A question of fact is a question which has to be answered in the backdrop of the facts, proof of which would depend upon evidence and consequential inferences drawn. So there has to be facts, there should be proof, and there should be inferences. Then a question of fact will be answered by the court. A question of fact derives its answer from proof or otherwise of facts which exist or do not exist. We argue before the trial court, we argue before the first appellate court. regular appeals under section 96. This fact does not exist at all. Court has come to a wrong conclusion. This fact does exist. Court has come to an incorrect conclusion. Yes. So based on this, whether proof or otherwise of existence of fact is answered while answering question of fact. But a question of fact is raised by the trial court in the form of issues. In regular appeal under section 96, first appellate court or lower appellate court raises the question of fact in the form of points for consideration. I always say that section 100, generally people say, oh, regular second appeal is a subject for for lawyers practicing in the high court. No. Lawyers practicing the trial court, lawyers practicing in the regular appeal courts, appellate courts, they should also be knowing about section 100. Otherwise, tomorrow the matter will go against their clients if these things are not taken care of. If you do not take care of facts in the first two courts, the second court, that is the first appellate court, is the last court of facts. Thereafterwards, we can't do anything with regard to facts. So how do we do it? While formulating, we should cultivate the habit of giving draft issues, or when the issues are formulated by the court, we should see whether the burden is put or the onus is shifted to a wrong person. Then we need to get it clarified. We need to get it struck off, and we should request the court to modify. These are aspects that we need to consider. Otherwise, when you go to regular second appeal, this will be a Herculean task. Now you see, a question of a fact generally are raised by way of issues or points for consideration by the first appellate court. These aspects will not be touched. Majority of the cases, in rarest of rare circumstances, excepting in rarest of rare circumstances, High Court will not touch into these aspects at all. But so this we have to keep it aside. We have to put it in bracket. We have to work on these aspects in the two courts below. Next, let us see what's a question of law. A question of law is one which the court is bound to answer only in accordance with rule of law. I cannot say this is the law, this should have been law, this was the law. No. What is the law? Applicable law. Based on that only, I as a judge can answer a question of law. Court is bound to answer only within the framework of rule of law. So, how does a court answer a question of law? Court answers a question of law which is already authoritatively answered by law itself. That means this precedent is like this, Supreme Court has said like this, larger bench has said like this, Privy Council has said this, authoritatively stated. Statute itself has stated. They will say section 101 says no other ground. In this case, no other ground which is there under section 100. All other grounds which are prescribed under section 100 are taken. So section 101 puts a limitation on the court. So I cannot travel beyond the court. Beyond the statutory provision. So this court is of the opinion that this case does not involve substantial question of law at all. So when a question of law has to be answered, court will say that it will answer based on what is already authoritatively answered by the law itself. Now you please see, question of law. Question of law may be related to application of law, interpretation of law, or what the relevant law is. With these three combinations, the first court also deals with questions of law. The second court, that is the regular appellate court, also deals with these aspects. Now let us see what would be the mixed question of law and fact, or question of mixed law and fact, they will say. This question of mixed law and fact is very difficult. Only when you are able to decipher or dissect between question of fact and question of law, you can take it to the High Court. For example, repeatedly we have heard the Supreme Court in several cases that limitation is a mixed question of law and fact. Nevertheless, if you want to address on that point in a second appeal, you have to make out a clear case that, look, as far as fact is concerned, I am not here. As far as law is concerned, I am here. Please consider this. The limitation in this set of facts should have been so many years, but not so many years. This is how we distinguish between a question of fact and question of law, and decipher it when it's a question of mixed law and fact. It's also called as mixed question of law and fact. See, one thing, in rarest of rare cases we come across this, particularly in situations where the question of limitation is there and you want to take it as a substantial question of law. The court will immediately say, no, look, this is a mixed question of law and fact. How do you overcome this? See, what's a mixed question of law and fact? You have to understand. In a mixed question of law and fact, facts are admitted. No dispute about it from both sides. And rule of law applicable is also undisputed. Facts are admitted. Applicable rule of law is undisputed. Then, what is the problem then? Whether the rule of law is correctly applied to the established facts or not is the question. Please see how difficult it is. Rule of law applicable is correctly applied or not. That's where I will take you through some judgments where it says misinterpretation or misreading of judgments. So here you have to bring it within the framework of rule of law not being correctly applied to established facts. Then you can say that this case has to be admitted. That's where you have to persuade the court. Now you say, if you want to know the distinction between law, facts, question of fact, question of law, etc., this decision may be helpful. 1997 1 SCR 748. Southam Inc. versus Director of Investigation and Research is a wonderful judgment that you should be going through. I request all of you to read. I request the youngsters to read from top to bottom you have to read. Then you will get to understand the facts and circumstances and how the law is laid down or how the law has evolved. All those things you will be able to note down. Now you see, how do you identify SQL? I always tell, it must be, I think it is Daftari only. He said half the lawsuits are either won in the office of the advocate or lost in the office of the advocate. Look at this. So if we fail to, whenever someone comes to us and requests us to draft a regular second appeal and file it and move it for admission, we do it in a haste. But we need to work hard. We have to be patient enough to identify that the case involves SQL, substantial question of law, and then only proceed further. See, how to identify a substantial question of law? If you read Hero Vinod, you will get wonderful insight into this aspect. And Santosh Hazari's case also gives wonderful insight. Nevertheless, I have jotted down some main points here. You know what a question of fact and what a question of law. The word substantial is prefixed to question of law. If it is just question of law, no, because before amendment also this question of law was there. That's where I told you to read section 100 before amendment and after amendment. Before amendment also section 100 was there. There that use of question of law, that expression is there. But the expression substantial was not there. Section 100 post amendment has a prefix of substantial to the expression question of law. So what is substantial? Substantial means which must be actual, which must be real, which must be existing. It should be there. And it should not be something which is seeming. It is seemingly there. It may be there. It's somewhere there. No. It should be evident. And it should not be imaginary. It should not be elusive also. These are all not my words. These are all used in several cases. Different cases, these words are used. So if it is just imaginary, if you imagine that there is a substantial question of law, no. You have to work and find out what exactly is the substantial question of law. Let us see how we can understand what exactly is a substantial question of law. How to identify? If you are for respondent, you have to identify whether there is a SQL, substantial question of law, as claimed by the appellant, because you have an opportunity to oppose that this case does not involve substantial question of law at all. That's where if you are for respondent also, you should know how to identify SQL or absence of substantial question of law. And if you are for appellant, you should definitely identify that the case involves substantial question of law. How to identify? It should be a question of law, number one. And it should directly and substantially affect the rights of the parties. There may be so many legal issues involved in a case, but what is that one particular question of law which affects the rights of the parties if it is not properly interpreted or understood? Error of law. Error of law is a substantial question of law. So you have to bring it within that, but that should directly and substantially affect the rights of the parties. For example, a daughter's right to equal share in the property post amendment of 2005. If this provision is not properly understood, what will happen? If my husband has left his parents, everyone got married to me and come this side, we don't have children, I die, will my husband have some right in the properties that I have got from my parents' side? May not be. So what is that? If this particular legal proposition is not properly interpreted, or if it is misinterpreted or misread, probably the substantial right of the party gets affected. It's under these circumstances, the court said a substantial question of law is one which should directly and substantially affect the right of the parties. When we are framing that particular single question, you should watch whether it caters to this need. Then it should not be covered by Supreme Court decision. It's already a settled law. The court has applied it. You can't say court has applied this law. Yes, it should apply that law. Privy Council has said so. High Court is, the lower courts are bound by that. Supreme Court has said it is bound by that. Larger bench decisions of the high courts are there. That's why the lower appellate court has given a decision in that manner. You can't say, look, following that decision, this judgment has come. No, you can't say that because it is already covered and it's a settled position of law. There you do not have a right. But you have a right in situations where it is gray areas, we say. It's debatable. It is not previously settled either by the apex court or by the Privy Council or by any larger benches. Then you can always put your hands on that. Supposing you are practicing in one particular high court of one particular state, the other high court has taken some other view, then you can say, look, this particular high court has taken this view. I would like to request the court and I would like to persuade this honorable court also to take similar view. That right you will have. It should be a debatable issue and it should not have been previously settled. So whether you can bring it within that framework also you can see. And a substantial question of law cannot be a question which is simply of academic importance. It should be a question of law which, if answered in one way or the other, should affect the decision of the case. I answer this question like this. The decision is in favor of plaintiff. I as a judge answer this question like this. The decision will be in favor of defendant. This is how you should frame a substantial question of law, which will definitely decide the fate of either of the parties. Very crafting of substantial question of law is very important. And a most important thing here is that it must arise from the findings of the court below. That's where you are appearing for respondents. You will take the judge through the findings of the first court and the next court. Look, the findings on XYZ points were this. The points for consideration of the appellate court under section 96 while exercising its jurisdiction was like this. Never from these questions, from these findings, you can get a question of law, much less a substantial question of law. That's how your argument will be if you are appearing on the respondent side. So it's always necessary that we go through the judgment of the trial court and first appellate court threadbare before going to formulate substantial question of law in our memorandum of appeal. Many a times, with utmost respect to the judiciary, I would like to say the court may formulate some substantial question of law. Still, you can persuade the court. My lord, probably these questions may not arise from the findings of the courts below. May I request the Honorable Court to kindly consider framing this question or any other question with utmost humility at your command. You can always request the court. Otherwise, what happens is, if there is an error in the formulation of substantial question of law itself, the entire thing will go. You will write that there are several judgments which says that the substantial question of law must arise from the findings of the court below. High Court may formulate a substantial question of law, but if it does not arise from the findings of the courts below, then you will lose the case. That's where we should be prepared to persuade the court and we should assist the court. I would rather say we should assist the court in such a way that these are the findings. From these findings, these are the findings of the courts below. You place it before the court. Maybe the ones formulated by you may not be acceptable to the court, but nevertheless, High Court will not go wrong. And it will formulate the questions based on the findings of the courts below. That's where you have to be very careful. I think time itself is, 7. We have come to section 7. Is it okay?
It's fine, ma'am. We can continue.
Huh?
We can continue.
Another 5 minutes?
No issues, ma'am. We can take the questions thereafter.
Okay. See, one more judgment that you can see is Boodareddy Chandraya versus Arigela Lakshmi's case. If you want to know what's not substantial question of law, you have to go through this judgment. AAR 2008 SC 380. This judgment is also a wonderful judgment. I request you to consider. See, next is construction of a document. This is a very, very powerful tool with you to see to it that the regular second appeal gets admitted. Read n number of judgments on this construction of document. See, an interpretation of a document which goes to the root of the title of a party gives rise to substantial question of law. Construction of a document means interpretation, misinterpretation, reading, misreading, all those things will fall. How to read a document, how to understand a document, how to interpret a document, all these aspects. That's where construction of a document, misreading, misinterpreting of a document. Chandrasekharan's case is P. Chandrasekharan's case is a classic example. AR 2007 SC 2306. And more than anything else, this Chunilal Mehta's case has been repeatedly referred to in many cases. So, if the construction of the document is neither simple nor free from doubt, then it gives rise to substantial question of law. Chunilal Mehta's case is prior to amendment, 1976 amendment, but nevertheless, courts have always relied upon this judgment. So that's where in many cases where we rely upon agreements and several clauses are there, contractual matters there, and heavy stakes matters are involved where the agreement itself runs into several pages and several clauses, or it may be a single page agreement but with different clauses which are not free from doubt, the interpretation of which can be either way, then you have a substantial question of law. See, Hero Vino's case beautifully says, inference of fact from recitals or contents of a document is a question of fact. In any document, we say so and so is the wife of so and so is the son of so and so. So this property is sold, this property is purchased, all those things. These are all facts. That's a question of fact, inference of fact. But legal effect of terms of fact, that is a question of law. Terms of document, what is the legal effect of terms of the document? That's a question of law. So while formulating a substantial question of law, you can say Exhibit P14, this is this document. The recitals are like this, the contents of documents are like this. Of course, these are all questions of fact. But what is the legal effect of these terms of document? For that, you have to mention. Then you will take that in your grounds, you have to mention that. And then you have to take it forward and formulate it in 2 lines as a substantial question of law. See, what is not a substantial question of law? Many times we argue so many things before the second appellate court. This aspect has not been considered. This aspect has not been considered. They may have some bearing, but it is not something which will ultimately decide the actual issue between the parties. Then the courts are not bound by that. Let us not waste our time on these aspects. What is substantially important, but not just collaterally or incidentally.
Probably she has lost the signal. She is just relogging in. Somehow there's a power cut at her place. So she's saying that she's going to log in through the dongle as well as through a mobile. Just be patient for 2 minutes. Meanwhile, you can post the questions on the chat box so that once Susheela ma'am joins in, so we can take the questions after the session. Those who are watching us live on the YouTube and the Facebook, they can also post their questions there.
Yes. Sorry, there was some.
Yes, ma'am, you can start off.
Yes. So I was just taking you through these aspects. In another session, some other time, we will go through some judgments and discuss as to what can be done if there is concurrent findings against us, and how to avoid the when the High Court can ignore the concurrent findings of fact arrived at by the courts below and still allow the second appeal. This is one aspect we need to consider. And second thing that we need to understand here is, as far as regular second appeals are concerned, is when can we request the court to formulate substantial question of law? It cannot be, supposing while dictating the judgment, at times the courts formulate substantial question of law. It is impermissible. Even though the judgment may be in our favor, we should always request the court, going by 100 subclass 5, and several judgments are there. We should always tell the court, request the court, that because of n number of judgments, it cannot be simultaneously proceeded with. Formulation of substantial question of law cannot be simultaneously done along with dictating the judgment. So it should be formulated first, so that the parties are informed about it and they may have to be given an opportunity. And second thing, that's one more thing that you need to consider here, is a regular second appeal cannot be dismissed on merits in the absence of the appellant or the party. There are judgments to that effect also. And perversity is one of the very, very important aspect. If you can bring the case that there is a perversity in the findings of the courts below or court below, then definitely a substantial question of law arises wherever there is perversity, because perversity per se is a substantial question of law. So these are all some aspects I would like to reinforce here. I'm sorry that there was some inconvenience because of the technical glitch. I'm extremely thankful to Mr. Vikas for giving this opportunity to me.
We are also thankful to you and Vikram and Associate, who was the connecting point. We have just received one message by Santosh Gavde. How to avoid cost being levied in the second appeal, which was never levied at the first appellate stage, while allowing amendments in the appeal memo?
In fact, these are all discretionary aspects. You can't avoid. These are all aspects which the courts will have to take a call upon. There is no particular law as far as.
it is also court craft how you handle the situation at that particular point of time.
In fact, in one of the judgments, Supreme Court has said that there was no substantial question of law in the memorandum of appeal. Then the court gave a number of days, permitted the party to incorporate those questions of law. It gave a number of days. Supposing it is not complied with, then the court will have to impose cost. In fact, it goes a further step forward and says that the notices on admission of a case should also include substantial questions of law. But in Karnataka, we don't have that practice. We get a notice. Supposing the case is admitted, we don't get what are the substantial questions of law on which it is admitted. But in one of the judgments, Supreme Court has said the notices will also have to include this substantial question of law so that the party will know.
As per our practice in Punjab Haryana High Court, we have to formulate the substantial of questions of law within the grounds of appeal itself.
That we are also doing. But when the notice is signed to the other side, will the notice also have that as a part of?
We believe that once you receive the grounds, you are already put to notice to that.
What if the court has formulated different question of law?
So that will be a situation normally.
That's where the Supreme Court's idea was to see to it that the substantial question of law formulated by the High Court can also be part of the notice. In one case that is there. It's okay.
So in that case, normally when the interim order is recorded, it says that this is the contention raised, and beyond that, this is also contention raised.
Maybe.
You normally put to notice.
Maybe.
So thank you, ma'am. Okay, this one question. How to overcome with the court how to overcome when the court formulates question of law in the interest of justice?
Interest of justice, see, that's what the courts have said. If you go through several judgments, some of the substantial questions of law formulated by the courts are termed as no questions of law, much less substantial questions of law by the Supreme Court. If you go through several judgments, when you read several judgments, you will come across, oh, this is not a question of law. This is not a question of law. This is not a though it may be a question of law, but not a substantial question of law. So you can't do anything, but you have to gently request the court that, look, this is what it is. Substantial question of law, it is not a blanket practice. We can't make use of such words. Rather, we can only request the court because you have an opportunity. As a respondent, you can always argue. Maybe the courts, with due respect, courts have formulated question of law, but law permits you to argue that those questions do not arise at all. You can always argue. That opportunity is given to you.
Yeah. Kavita wants to ask a question, probably.
Section 151 will prevail over one section. No way. No way.
Good evening, ma'am. As usual, wonderful session. Thank you, Vikas ji. The issue I just wanted to put forward here is that some of the courts have the practice of just saying that in the interest of justice, or just saying that like to bring the overall finality to the issue, I am bringing up this question of fact.
Question of fact will not say, question of law only.
No, they will term it as question of law, but it will be actually a question of fact.
That is for you to substantiate. When you receive a notice, when you are requesting the court to consider, then you will gently say, look, I have this power under section 100. It specifically gives me a power as an advocate for the respondent, or I am a respondent myself. I may be permitted to persuade the court to say that the question formulated by the court does not fall under the category of question of law or substantial question of law, number one. Even if it is a substantial question of law, it is not involved in the case. That's where this is a session which has to go for 4 or 5 parts we have to do. What is involved, that itself Supreme Court has said. It is not just substantial question of law. It should be involved in the case.
Exactly, exactly. That's what I was just trying to put it. How to make such kind of a judgment or such kind of a presumption of the judge of the court as redundant, or there's a bar where we can place.
See, the court in its wisdom has formulated some question of law. It is for you to persuade the court, look, this question of law does not arise. or even if it arises, it is not involved in the case on hand. These are the two opportunities for you. It is for you. It is not the, you can't blame the court.
It's not the blaming the court. It's that even in the regular practice, when we just say the court, this under section 100, this court is restricted with only the substantial question of law, and this is what is being presented. And even when we present the written counter or the written arguments, it comes back with the judgment saying that in the interest of bringing a finality to this issue, we are taking this up.
Then if you are aggrieved, you have to go a step forward. Section 136 is a very, Article 136 is a very, very limited scope. If you go in SLP against concurrent judgments, it's very difficult, very, very difficult. 136 Supreme Court exercises power where what you say is correct. Otherwise, it's a very narrow margin.
Thank you, ma'am.
Thank you, ma'am, for the insightful session. As usual, people will have too many takes away from the present session. And as you shared that it will take 4 or 5 sessions, we would look forward for that insightful sessions. Before we part for the day, I will request ma'am to share the book again, and I will ask her to share the link so that we can post it on the WhatsApp groups and the Telegram groups if anybody wants to buy the book written by ma'am. Yeah, this is a substantial question of law by S. Susheela, senior advocate from Karnataka High Court. So once again, on behalf of Beyond Law CLC and Trikram and Associates, we thank Ma'am S. Susheela, senior advocate, a trained mediator, author, and a columnist, for sharing her insights. Thank you, everyone. Stay safe, stay blessed. And tomorrow we have a session, since we have the topic of our sessions are known as Beyond Law CLC. So tomorrow we speak on how to improve the English. Very basic topics, because a lot of young lawyers and aspirants for judiciary and other exams request us to take English. Tomorrow will be Right Propositions and Right Language by Mr. Vasant Patwardhan. So do stay connected with us tomorrow at 6 p.m. Everyone